attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the first in a Lawcast series talking about Form 8K. On September 26, 2016, and again on the 27th, the SEC brought enforcement actions against issuers for the failure to file 8Ks associated with corporate finance transactions, and in particular, PIPE transactions involving the issuance of convertible debt, preferred equity, warrants, and similar instruments. Prior to the release of these two actions, I have been hearing rumors in the industry that the SEC has issued hundreds of subpoenas to issuers relating to PIPE transactions, and in particular to determine 8K filing deficiencies. Although hundreds is likely an exaggeration, the SEC is certainly focusing on this space. Back in August 2014, the SEC did a similar sweep related to 8K filing failures associated with three A10 transactions. The 8K filing deficiency actions were a precursor to a larger SEC investigation on three A10 transactions themselves, which culminated in two well-known enforcement actions against active 3A10 participants, i.e. the Ironridge companies and IBC Funds, and resulted in a chill on the 3A10 activity in the industry as a whole. 3A10 actions continue today, but the volume of transactions has dramatically reduced, and the attention to due diligence, detail, and reporting requirements has likewise increased. The SEC rarely takes enforcement action or expends time or resources on investigating the failure to file a Form 8K. When such issues arise, it is usually in connection with a routine review of a company's SEC reports or as part of the comment and review process associated with the filing of a registration statement. All reports filed with the SEC are subject to SEC review and comment, and the Sarbanes-Oxley Act requires that the SEC undertake some level of review of every reporting company at least once every 3 years. As was the case with the SEC's investigation into three A10 transactions, it is my belief that the SEC is reviewing the PIPE industry as a whole, and in particular, the process, procedure, and effects associated with convertible instruments. The majority of these transactions involve the issuance of convertible notes, which then convert into common stock following a holding period in reliance on Rule 144 and Section 3A9 of the Securities Act of 1933. Any convertible instrument can be used in the same manner, such as preferred stock and warrants. The use of convertible instruments in PIPE transactions is perfectly legal and acceptable. However, like any other aspect of the securities marketplace, it can be abused. My belief is that the SEC is using the investigation into the failure to file 8Ks in association with these transactions to assist in a larger investigation into related fraud and other violations. If a company is failing to file an initial 8K for the transaction and subsequent 8Ks to report the issuance of securities upon a conversion, there may also be other issues and violations. Examples of abusive or improper activity could include the backdating of notes or the failure to provide the funding associated with the note, improper undisclosed affiliations between investors and the company or its officers and directors, manipulative trading practices, improper stock promotion, or trading on inside information. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.